Chakraborty, Dean School of Law, University of Engineering and Management. I would now like to request ma'am to felicitate Advocate Shishano Banerjee, Senior Standing Counsel, Government of West Bengal. I would now like to request our head of the department, Dr. Bonita Bose, to kindly felicitate Dr. Siddharth Goswami, Advocate, Supreme Court of India and High Court at Calcutta. I would now like to request ma'am to kindly felicitate Professor Dr. Manik Chakraborty, Professor Emeritus, School of Law, Sister Nivedita University. Thank you so much to all the dignitaries and respective judges. I will now request everyone to please take their seats because we will be starting the session. With the permission of the judges, can the session begin now? Okay. So students, you can take over, court officer.
who are the petitioners? Who are the petitioners?
The state, we are the petitioners.
Okay.
The council seeks permission of this honorable bench to address them as lordships. Much obliged. Your lordships, I will be addressing issues 1 and 2, and my co-counsel will be addressing issues 3 and 4. Your lordships, before proceeding further, may I know if the bench is well versed with the facts of the case?
Yes.
Much obliged, your lordships. The council may now proceed to the first issue, which is whether the present appeal is maintainable under Article 136. Your lordships, the council humbly submits that this petition is maintainable under Article 136 because it involves substantial questions of law.
No. This question is not relevant. If you come to page number 3 of the fact sheet, it has already been clearly stated that it has been admitted. So better not talk on issue number 1 at all. You come to issue number 2.
Much obliged, your lordship. The second issue deals with whether the state government of Bongo Pradesh has acted lawfully in preventing the trailer launch in the absence of a censorship certificate under the Bongo Pradesh Act 1974. Your lordships, the state has indeed acted lawfully. The 1974 Act makes pre-certification of all film publicity materials mandatory and not optional. If your lordships could kindly refer to page 18 of the petitioner's memorial, under point 2.1.2, section 6, subsection 3 clearly states that no distributor, producer or exhibitor shall display any publicity material without a valid certificate of censorship. The respondents have failed to produce such a certificate, and therefore the police intervention was not arbitrary, rather it was simply the enforcement of the statute. Further, it has been held in the case of K.A. Abbas versus the Union of India 1970 that prior censorship, if it is backed by law and guided by procedural safeguards, it is a reasonable restriction under Article 19 subsection 2. The same principle is applying in the present case as well, because the state was merely ensuring compliance and not suppressing expression. Your lordships, Article 162 of the Constitution of Sindhia, which is akin to the Constitution of India, the state government possesses the executive power to enforce laws that have been enacted within the state's legislative competence, and the Bongo Pradesh compulsory censorship of film publicity materials 1974 is a valid statute and is within the state's legislative competence. Your lordships, the petitioner's action was also a reasonable restriction. It was not about the film's content. It was about the procedural non-compliance. The trailer launch could have proceeded the very next day if the respondents had obtained the certificate. That itself shows that the restraint was temporary, proportionate and content neutral. It is further submitted that the entire purpose...
Under which provision of this act that you are stating you have banned this film trailer? Which provision of this act? Try to
Your lordships, under...
Also highlight that this is temporary. Any ban that has been given under this particular enactment is temporary. You said it's temporary.
Yes, your lordships, for the first question, under section 6, subsection 1 of the West Bengal Cinemas Regulation Act 1954, it has been stated that if the state government believes that showing a film might cause disturbance or violence, then they can order to stop or ban the film. And in the present case...
Have you given a notice to the other side?
Your lordship, as per the facts of the case, the state had itself demanded the ban, and the state had to act immediately. Hence the ban was imposed.
Is it a non-obstante clause? Does it has overriding effect over the existing constitution?
Lordship, the which is the Compulsory Censorship Certificate Act, that is the States Act regarding the certification of publicity materials. But the Union Act, which is the Cinematograph Act, that is dealing with certification of films. Films and publicity materials both are different subject matters, and hence the objective of both the acts are different. Hence the states...
No, my question is why you banned it? Why you banned it? What is your logic behind it?
The Lordship, just after 1 week of the release of the movie...
Now, do you, this is also follow-up question, do you ensure that all the trailers that's launched undergo this strict vigilance of this act?
Lordships, as per the facts of the case, when the police had intervened at a trailer launch event, because the certificate that is needed for the trailer launch, that was not obtained by the respondent. Hence, the police had intervened there to apply the provisions of the States Act itself.
You have already said that we are not disputing on this point.
Yes, sir. Yes, Your Lordship.
Under which provision? It's mandatory.
So in the definition of publicity material, the trailer has to fall within publicity material. So under which provision will the trailer fall under publicity material?
Yes. Your Lordships, under Section 2G of the Publicity Materials Act.
Yes,
It
it
is
has
defined-
6 subsections.
Yes.
Under which are you putting a trailer?
Yes, under the publicity material, the first line states that it includes any material that is used for the promotion of the film, and the trailer is itself a promotional material. Hence, it has been considered as the Publicity Materials Act. And again, Your Lordship, there is a very recent case on this, which is the Yashraj Films Private Limited versus Afreen Fatima Zaidi. There it has been stated that trailers are merely to attract the audience. It is for promotion.
What is the meaning of the principle of cautious omniscience?
Pardon, Your Lordship.
Cautious omniscience means like the legislators are at liberty to interpret certain things only on the basis of a particular provision that has been specifically mentioned. Say, for example, if I ask Mr. X, stand up, he will stand up and all other people will sit down. So the word trailer has not been given here in the particular provision that you're highlighting. Do you have any supporting judicial interpretation in this regard?
Yes, Your Lordship. I would also. Yes, Your Lordship. Also, if I apply the principle of
Before you
adjustment.
answer, we are missing that word promoting. You said the word promoting is there in the definition.
It is providing publicity to the film. Providing
For giving
publicity.
So you are putting that within that bracket of for giving publicity of a film.
Yes, Your Lordship.
So trailers comes within this. A case.
Yes. Yes.
Yes, that
Yes,
is the
Your
need.
Lordship.
Yeah.
It is a very recent case, which is of the Yashraj Films Private Limited versus Afreen Fatima Zaidi, 2024. It has been stated there that the trailers are merely to attract the audience. It is for the promotion purpose. Hence, it can be considered as a publicity material. Much obliged, Your Lordship.
So in this provision, there is a place for giving a notice before you apply the power vested on the state. Or it
Lordship,
is.
could you please repeat?
My question is there a principle of natural justice that being followed in this particular enactment, and you're following that with this particular matter? Because if the other side would have knew that there is a ban, they would have not showed up and there wouldn't have been any chaos, which actually led to some demonstration on the road.
Your Lordship, the ban was of the film. Issue 2 is dealing with the police's intervention regarding censorship of the publicity material. So hence, that's why during the trailer launch, the police has intervened. In fact, under Section 8A of the Compulsory Censorship Act, it allows any police officer to enter, search and seize any publicity material that has not been certified under the States Act.
And then you allowed the film to carry on in the state?
Uh, the-
And which act now you apply to ban the movie altogether?
Yes, Your Lordship. Your Lordship, under Section 6, Subsection 1 of the West Bengal Cinemas Regulation Act, 1954, if the state government or the district magistrate... Pardon, Your Lordship. Pardon, Your Lordship. The Bongo Pradesh Cinemas Regulation Act, which is akin to the West Bengal Cinemas Regulation Act, under Section 6, Subsection 1, if the state government or district magistrate believes that showing a film might cause disturbance or violence, they can order to stop or ban the film.
So what led you to this particular thought? There was nothing substantial. when you banned the trailer, there was nothing much.
Your Lordship, we have not banned the trailer. We have posed a temporary ban on the film. The trailer launch event was intervened by the police to stop because that trailer, for launching the trailer, the censorship certificate was not granted.
So now suppose if they apply, will you grant right now? Would you place an order in that regard?
Your Lordship, there is a specific time limit. Pardon
Yeah.
me,
Will you do that? Like, that's the question.
If it has passed 6 months and yet if they have not applied for the certificate, then we cannot grant them.
Okay.
Your Lordship, the issues 3 and 4 will be addressed by my co-counsel. Much obliged, Your Lordship.
Firstly, I convey my utmost respect to the bench and my learned opposition counsel. With the further approval of your lordships, I may proceed with issue number 3. Much obliged, your lordships. Issue number 3 deals with whether the ban imposed by the state government is constitutional, read with Article 19(1)(a) and Article 19(2) of the Constitution of Sindhia, which is akin to Constitution of India. Firstly, there has been a reasonable restrictions as to maintain public order, as after 1 week of the release of the film, there were blocked roads, public riots by several student groups, freedom fighters associations group, the descendants of the freedom fighters were revolting, and various other political groups which were involved in these all riots.
So what's wrong in this?
So,
It is your administrative failure. How you can blame that on someone
Everyone
else?
has a right to demonstrate peacefully without arms. What's going wrong with that?
roads were blocked and
And
So
that
you
is-
should maintain the roads. It is your administrative failure.
And
because
apart from that, nobody has seen the film.
Your Lordship, the film has been passed for 1 week and people has seen the films and then this revolt has started. I would like to refer...
no film after seeing the film, even if revolt has started, whatever you are submitting, that is your state prerogative. You are unable to maintain peace and order, isn't it so? Because they have already got their certificate. They are cleared from the censor board, so they have their proper certifications. That means that film has been censored. After proper censoring, it has been passed. So once it is passed, and if certain thing happens, then it is a state prerogative. You have failed in your administration somewhere. How you can blame
See,
it on them?
all the films and everything are basically expression of art.
Indeed, Your Lordship.
Right. So I think Kolkata is a very, or even West Bengal is a very mature place where, like, everybody accepts almost everything.
Your Lordship, I would like to cite a case on this matter. May I? Much
But your
obliged.
case will turn on the facts. So, if you are applying 19(2), was there a subjective satisfaction that there was a disruption to the public order? Because what my brother is saying on the bench is that they have a right of freedom to speech and expression that you
Indeed,
can
Your
curtail only if there is a disruption to the public order. In this fact, there is nothing about foreign relationships, etc., or sovereignty. We are only concerned about public order. Was there a subjective satisfaction on this disruption of public order for invoking 19(2) to curtail 19(1)(a)?
May I answer that question, Your Lordship?
Yes.
Yes.
Looking forward to that.
Along with my learned brother's question, both.
All right, Your Lordship. please refer to the proposition once. Page 2, the last paragraph. Within just 1 week of its release, citing the need to maintain public peace and order, the public demanded immediate ban on the movie. The public. Your Lordship, there was a reason of social security, as the police were clashed with. The police clashed with the groups and associations who were blocking the roads. The police tried to administrate such matters, but they had failed to do so. The pressure was on the state to maintain the order.
That's with the set of people and the state. We are not interested in that. We are interested in the movie. Are you getting my point clear?
Yes.
Some people comes and demonstrate. You'll find every other day some people, set of people comes and demonstrate. Now the question is it to that extent that the movie needs to be completely banned?
Your Lordship, the groups, the social groups who are protesting claim that the movie contained deliberate distortion of historical events and wrongly attributed
Have you set
actions.
up a team to check the claims before you move into this banning?
Was any case filed against that on that pretext that it is a disruption of history, whatever you are submitting?
Your Lordship, a case has been filed before the High Court of Bongo Pradesh, where the High Court has concluded and opined that this...
No, not relating to that. You are submitting.
We must know that there is a restriction upon them to go beyond the moot proposition, and there is no mention of filing of any case or otherwise.
Yes.
So it is cannot be answered by them because they cannot go beyond the
Because
moot
they are
proposition.
submitting that there is
That is in the-
disruption
that is
and
in the
there is
pro-
distortion of history.
Yes, that
So,
is in
to
the
assert-
proposition.
Hmm.
That is in the proposition. It is mentioned in the proposition,
FIR is not mentioned.
but FIR is not mentioned.
Yes.
But that's why he cannot go beyond
No.
this.
You cannot go beyond pleading, but you have not substantiated.
If it is not mentioned, then it is not there.
I think it will be easier if they just answer that it's not there because you are more versed with the facts. So you can say that it's there or not there. It will be easier for us also. Yes.
You cannot go beyond pleadings. Whatever you have pleaded, you cannot go beyond that. And according to your pleadings, there is nothing what you are submitting right now.
Are you getting the point clear? The pleading that you're doing is with the flow of the scenario. That is not something that we're looking forward to. The court will only look into the facts and circumstances placed before it. Unbiased. Okay?
Followed, my Lordship.
Please follow what's given here. Try to construe your arguments in furtherance of this. Don't go beyond it. If you don't have any critical it's not there in the facts. I'm getting my point.
We will not hold it against you.
Yeah, we'll not hold it against
After asking, we realized that FIR is not mentioned here. So we ourselves realized that, but you can answer that it is not there because you are well versed with the facts. We are only judging you. It will also
Followed,
help
your
us
lordships.
in not carrying with the question.
Followed, your Lordships. Your Lordship, I would like to cite a case over here. May I? Your Lordship, I've already mentioned them. May I mention them once more?
We'd like to know how do you interpret free speech? Yes. And how you think is that this particular bill is against the notion of free speech. One point I agree and accept is that there has been some problem with the historical facts that has been given. Apart from that, what are the other things you think? There's so many movies, they're not documentary. There will be movies
until and unless there is certain thing which has been taken up by that historical person who has taken a specific plea of impersonation or whatever. In this case, neither you have pleaded that portion nor you have anything to substantiate, right? So you cannot take that plea right now that he has a different FIR or anything, whatever may be.
I followed your lordships.
Then it is okay.
Follow. Your lordship, as you have asked the council on the context of free speech. Free speech is something until and unless a person, an individual can express their minds and expression via words, until and unless it's violating the decency of and morality and fundamental rights of any other individual, or implementing public unrest or social injustice.
So they have done nothing beyond that.
Your lordship, indeed, your lordship. I would earnestly request the judges to refer to Article 19(2) of the Constitution.
Okay, please.
Nothing in subclause A of clause 1 shall affect the operation of any existing law or prevent the state from making any law insofar as the law imposes reasonable restriction on the exercise of security of the state.
That reasonableness is important. That is what everyone,
Indeed, your lordship.
all our brothers are asking. What is the reasonableness? Please explain it.
The one is the security of the state, your lordship.
That is a state prerogative.
The state is failing to administer such bans. Like priorly, the publics who are revolting against the film has clashed with the polices. The state has taken administrative actions against them, but they have not been fulfilled. The police has clashed, and the material, the situation is beyond the control of the state, and the state was hence compelled to instigate the ban. Under section 6(1) of
You
the
are
Bongo
appearing for the
Pradesh
state.
Cinemas-
If you say that it is beyond your power, then we as the Supreme Court will have to suggest the emergency should be declared. You are for the state, you are state's council, you are saying it is beyond my control. How can you make that submission? Your client is state, your client is not an individual, right? So make submissions within that four corners of knowing your client.
Your Lordship, the ban has been imposed under Bongo Pradesh Cinemas Regulation Act 1954, Section 6(1), which deliberately expressly mentioned that in case public exhibition of a cinema has instigated public riots and public disorder and unrest in certain situations, the ban can be imposed. The state government has the authority and authorization to impose such bans over such places.
But the clash has not happened during airing or publication of any cinema, publishing any cinema. You have stopped it before even it is published. So how you can substantiate that? No. See, reasonableness in restriction is once something is published, then after effect, one is pre-effect and one other is after effect. After effect, certain thing happens and somewhere state cannot manage it, whatever you are submitting. But here it is not even published. So how you can say that it's a consequence of this?
Yes, Your Lordship, the film was published, and after 1 week of its publication, the ban has been imposed.
Within this 1 week, the disruption happened, or after the ban happened?
Within this 1 week, the disruption happened. And under Schedule 7 of the Constitution, Entry 1, public order comes under the sole authority of the state to maintain.
Can you cite any case law where similar situation has happened?
Indeed, Your Lordship, may I?
Yes.
Much obliged. In the case of Ranjit D. Uresi versus State of Maharashtra, as mentioned in the memorial in page number 25, I would request the bench to refer to the petitioner's memorial once.
Page number
25. In this case, the Supreme Court held anything so indecent as to deprive or corrupt public sanity or public order must be taken down.
which case law and page 25?
Ranjit D. Uresi versus State of Maharashtra. Your Lordship, shall I state the facts of the case?
Along with that, you have cited Obik Sharkar versus state also. Was that order passed in state's favor, or was it passed in favor of the petitioner? You have cited here at page 26. Please see, you have stated along with Ranjit, you have referred to Obik Sharkar.
Indeed, Your
Was it
Lordship.
passed in the favor of state? Because we believe the order was passed against the state.
May I take a minute from the bench?
Yes.
Much obliged, Your Lordships. The court in the state adopted the community standards test.
What is the ratio of the judgment?
Supreme Court allowed the viewing of the movie. I think Bhuvishyadev Bhoot the movie was.
You cannot take only one point. You have to consider the ratio,
Judgment
right?
as a whole.
What is the ratio?
Judgment has to be read as a whole. It's not a statute.
May I proceed, Your Lordships?
Yes, on this.
Your Lordship.
Why you mention this particular case? Have you got a printout of that particular case? And why you mentioned it here?
No, see, in a judgment, you cannot rely on a specific point. You have to take into consideration the ratio of the judgment, right?
See, even when we do not know before the courts, we say that we do not know.
Your
It's
Lordship,
better to say we do not know than face 10 more questions. See, Obik Sharkar was a criminal appeal where the accused had went before the Supreme Court saying that the charges will not lie against me. Your case is different. So we wanted to know how it will help you.
I would like one.
Obik Sharkar's case was certain provisions of IPC is not applicable for Obik Sharkar. Right?
Your Lordship, I would pardon, Your Lordship. We seek pardon for our ignorance.
It's okay, that's fine. Just say it. It's all good. Yeah. If there is no problem.
Agreed, your lordships. May I proceed with them? Much obliged. CVFC certification is not exhaustive as it certifies the content and do not assume the public reaction from it. Hence, the state can implement their authority over the sighting and public exhibitions of the film. Here, I would like to request your lordships to please refer to the Schedule 7 of the Constitution. Under that, List 1, Entry 60 deals with certification of the movies and cinemas, whereas in List 2, which is the state list, Entry 33, it deals, again the state deals with dramatic performances
But
and
subject to
cinemas.
entry 60. Entry 33 says subject to entry 60.
Subject to Entry 60. Indeed, my lordships.
Then according to you, which one will override whom? Entry 33 in list 2 does not operate singularly. It operates subject to entry 60. So entry 60 has to be read first, apart from the fact that list 1 is a union list.
Indeed, my lord.
And your action will be repugnant if it is against entry 60.
May I proceed with my answer, your lordship? The Cinematograph Act, which is the Union Act, in its section 4 explicitly mentioned that it deals with the content of the film and does not have any control over the public reactions which happens after the film is released. And hence the Union list on 60 deals with the pre-release provisions of the film, whereas the entry 33 of state list deals with the post-release provisions. Hence, it's not mentioned in the concurrent list, as held in the cases of Union of India versus Motions Pictures Association 1999, which further precedent to the judgment of Prakash Jha versus State of Uttar Pradesh. May I proceed with my next point? The state imposed a temporary ban within the vicinity of the state and not a complete ban. The filmmaker himself is of a controversial repute, and hence such actions were calibrated. The state actions were subject to court examinations, and hence under no entitlement the respondent could have made any false fallacious allegations against the CM of the state, which is Miss Dayamati Banerjee. With the
I think prior to all these issues are not relevant in this case.
by fact, your
Made what comment against whom does not matter.
We will go by the law.
followed your lordships. Followed your lordships. With further approval of the bench, I would like to start with issue number 4. Much obliged. The issue number 4 deals with whether the state government under West Bengal Cinemas Act 1954, here stated as the Bongo Pradesh Cinemas Regulation Act, possesses the authority to override or supersede the certification granted by CVFC.
That is not the end. There is still something left.
Pardon your lordships, particularly in extraordinary circumstances where law and order is at stake.
How do you interpret extraordinary circumstances?
In circumstances which are not precedentally mentioned in any cases or cited by any laws, or further priorly dealt with by the courts of Scindia.
Has the court signed any case then where this extraordinary circumstances list has been provided? Then can you give me that
Pardon Pardon your lordships, I'm ignorant of that fact. May I proceed with the issues? The federal schemes permit state intervention in public order and exhibition of films. The CBFC regulates content pre-release. The state retains the jurisdiction of films post-release and exhibition throughout the vicinity of the state and the boundaries it's authorized to. I would like to request your lordships to turn page number 29 of the memorial submitted and refer to the case of Union of India versus Motion Pictures Association, where the apex court has acknowledged such duality. I would. Your lordship, I would like to take a minute for that. May I?
What do you understand by proportionality test? How you will test the reasonableness, whether some extraordinary situation has occurred or not?
Your lordship, each actions taken by the state or any administrative authority should be backed by the equal number of reasons for doing such.
Which have to be reasonable, and there are several parameters for that, right?
Have you heard of the spark in the powder keg?
Pardon your lordship,
The spark in the powder keg.
pardon your lordship, I'm not compliant with
That is your test for reasonability. That whether it sparks the powder keg or not, and everything will blow up once the spark is there. It is in S. Rangaraj, which you have cited profusely, both of you. Check that before the rebuttal, it will help you.
Beg my pardon for my ignorance, your lordship. I'll take a minute to search up any recent cases if I can find one. Am I allowed to do so?
It's okay. You carry on with any other points of arguments you have for your favor.
Followed your lordships. CBFC certification under section 3(5)(a) and 5(b)(1) of the Cinematograph Act 1952 does not confer absolute immunity from state actions. Your lordships, please refer to page 29 for the supporting case laws.
In which case, you're deciding against all. The same case.
No, your lordships. I'm citing Babulal Parathe versus State of Maharashtra and Virendra versus State of Punjab.
What do you mean good faith? You have stated. What do you mean by good faith? How you will define good faith? The ambit of good faith is enormous and huge.
Your lord,
And also reasonable regulations. What do you mean by reasonable?
your lordship, reasonable.
We start with good faith. One by one.
Followed your lordships. Firstly, I'll come to the point of good faith. Good faith refers to anything that is done for the betterment of the society or for the people at large, or done in for any notions that has a positive effect on the future. Your lordship, it's the council's interpretation. In the statute of DPDP Act, I have complied with the terminology good faith, but it refers to something completely different as in relevancy over in this matter.
You go through the term ubermae fide, you will get entire.
Absence of any malicious intent. Lordship, may I proceed with the next part of your arguments? I beg my pardon for such. Your Lordship, preservation of public order is a constitutional duty vested upon the state under Article 162. CBFC certification cannot foresee post-release repercussions under any circumstances. The post-release reactions of the people remains uncertain. The temporary ban satisfies the proportionalities test and being narrowly tailored, necessity and time bound to avert violence while preserving free expression. The union and state power operates harmoniously and not competitively. Temporary suspension complements CBFC regulations, ensuring both content control and public safety within constitutional limits. With the further approval of the judges, I shall like to proceed with my prayer.
Proceed.
Much obliged. Wherefore, in the light of the facts stated, issues raised, authorities cited and arguments provided, it is most humbly prayed before this Honorable Supreme Court of Sindhia that it may be pleased to adjudge and declare the validity and reasonableness of temporary suspension of the order imposed by the state government. The action of the state falls within the permissible restrictions under Article 19, Clause 2. Affirm that CBSE certification does not preclude limited and time-bound state intervention in exceptional circumstances as such this one. It is rightful authority of the state to impose such ban in order to maintain public order within the vicinity of the state and pass any other order or at it may deem fit in interest of justice, equity and good conscience, and for this act of kindness the counsel for the petitioner shall ever pray for. Much obliged, your lordships.
We have a couple of more minutes. I have one more question. 2 minutes, yeah, Pablo.
Followed, your lordship.
You say that you have given a temporary restrainment order,
Indeed, your lordship.
right? So how temporary is it?
As per the West Bengal Bongo Pradesh Cinemas Regulation Act, Section 6, subsection 3, such orders shall persist not more than 2 months. Your lordship,
Meaning the appeal itself might have become infructuous. Why should we at all decide anything if it is infructuous? Your ban has died a natural death. Nothing left to be decided. So why should the court waste its time?
So now comes the question of good conscience, that you have spent government exchequer money coming so far, how it is justified.
And you've never said any of the statements that you want to carry on with the ban.
the temporary ban, your lordship, the temporary ban was lifted by the High Court before 6 months, and currently as the court is still persisting with the matter, res sub judice will pertain over such matters.
After now, things will be resolved. So from tomorrow onwards, they will start displaying the movie.
In the favor of this court and the facts cited, if the court seems fit that the public order of the state has been restrained and has put into its normal state,
We can't do it because we want to pray for it. We are an unbiased set of people trying to give justice to the people of the country. If you have any prayer, you have to pray.
pray for for mercy from the bench, but
Then you want to withdraw. You want to withdraw this appeal.
Indeed, no. No, Your Lordship.
We will give leave for that.
The council's ignorance can't be the reason for the suffering for the whole state. We
No, if you
pray for
withdraw,
mercy from
it will levy some suffering upon the exchequer. It will save some dates.
we pray for mercy from the honorable court for in such insights. Much obliged, Your Lordships.
We'll take a couple of minutes time in between, and then we will ask them to start.
address the bench collectively as your lordships. Much obliged, your lordships. The council appearing before the Honorable Supreme Court of Sindhia in the matter of State of Bongo Pradesh versus Vikas Jalhotri and another on behalf of the respondent Vikas Jalhotri. If your lordship is well versed with the facts of the case, the council seeks permission to move directly towards the issues. Much obliged. May it pleases your lordship, there are 4 issues framed in the present case. Two shall be addressed by me, and the remaining 2 will be addressed by my co-counsel. The first issue is whether the present appeal filed by the state government of Bongo Pradesh before the Supreme Court of India is maintainable under the constitutional scheme of the appellant jurisdiction. Your Lordship, the counsel of the respondent submits that the present special leave petition is not maintainable and is void of any merit. To support this submission, it is bifurcated into 2 parts. Firstly, that the appeal neither has substantial question of law nor any miscarriage of justice. Your Lordship, I would like to. As it pleases your lordship.
But anyways, when you have started on that, I would like to know only one small question. What do you mean by substantial question of law?
Yes, your lordship. It has been determined and explained in the case of Chandrabhan versus Saraswati.
What are the constitutional interpretation of this word?
Yes, Lordship, when a topic is still debatable and has not been settled by the Supreme Court and can call for an alternative view, then it will be considered to be a substantial question of law.
What are the questions that comes within the very of substantial question?
Your Lordship, a question of law can become a substantial one when it is of public importance or has a great relation to the rights of the parties, and also when it is debatable, it has not been solved in the has not.
We go to the next issue.
Yes, as it wishes.
Well, just one thing. Does 136 require a substantial question of law? Article 136 requires a substantial question of law.
Your Lordship, in Mathi Arthirat Jobe case, it has been stated that in certain circumstances only when the SLP will be entertained. One of them was a substantial question of law.
But it's the discretion of the Supreme Court to admit a special.
Yes, Your Lordship. Under Article 136, the Supreme Court has been has a wide discretionary power to entertain any matter within the Supreme Court of India. Yes, Your Lordship. As it. As it pleases your lordship, the issue number 2 is whether the state government of Bongo Pradesh acted lawfully in preventing the trailer launch event in the absence of censorship certificate under the Bongo Pradesh Compulsory Censorship of Film Publicity Material Act 1974. The Council of Respondents humbly submits that the government of Bongo Pradesh has acted unlawfully in this regards to support. Yes, your lordship, my following submissions will explain why the actions of the police as it pleases your lordship. So the firstly, that the state's requirement of a separate trailer certificate amounts to unconstitutional duplication of the central regime. Your lordship, trailer as a part of the film is under the CBFC certification and not the trailers and not the state's law. Your lordship, it has been stated in not a provisional list that entry. Your lordship, cinematograph itself do not have the term trailer in it. However, your lordship, in Rule 38, it is of Cinematograph Act. Rule 38 of Cinematograph Act, Rules 1983 has Yes, Your Lordship. Rule 38. Yes, Your Lordship. The cinematograph certification rules 1983. Yes, Your Lordship. In the compendium, I may tell, I may in the page. Your Lordship, page number 7.
Yes, yes, rule 38. Okay, then.
In which page?
Page number 7.
You're mentioning.
Is it transmissible because it is not in your proposition?
Your Lordship. Yes, Your Lordship, it is. No, Your Lordship, even rules have been mentioned in the moot proposition in the page 15 of the memorial for the respondent, para 14. Para 14. 14, Your Lordship. 14. 14, page number 15. Your Lordship, page 15, para 14. Of under 2.1, Your Lordship. Yes, Your Lordship. In a compendium, no, Your Lordship, it has not been mentioned in the moot proposition.
The law point, they are arguing the law point, let them argue on law point. Yes, yes, please proceed. I think we will allow you.
Much obliged, Your Lordship. So it is regarding the advertisement of certified film, and there the and it, no, Your Lordship. I don't have the full copy of the rule. However, I have mentioned it in the compendium and as well as in the memorial.
Probably this is.
Yes, Your Lordship, I have submitted the compendium as well.
Yes, this is probably. This is rule 38.
Much obliged, Your Lordship. There, yes, Your Lordship. The rule 38 states that any person advertising a film needs to exhibit the certificate even when it comes to trailers. This shows the trailers are under the central regime, Your Lordship, and when a trailer has already been under central regime, there is another case that is the trailer of Talapati Vijay's Leo. The movie Leo, the trailer of that movie was uncertified, and because of which the so-called notice was sent by the CBFC. This again shows that the trailer comes under the purview of the central law, and therefore the state cannot ask for a separate certification because that will lead to duplication of certificates.
We don't buy your argument anyways. Any other thing that you want to say in this regard?
Yes, Your Lordship. There is an invalid application of Bongo Pradesh Compulsory Censorship of Film Publicity Material Act. Your Lordship,
Before you begin, I just want to interrupt. See, one thing is about the content of any specific art, whatever you are publishing, and another thing relates to its publishing. So, about the trailer which you are speaking, this certification, whatever you are speaking, Rule 38, it speaks about the contents. It has to be marked, whether UA or adult
yes, Your
or
Lordship.
universal. deals mainly with the contents,
Yes, Your Lordship.
but it nowhere deals with the publication.
Your
Post
Lord- Yes, Your
publication its effect or pre-publication its effect, it mainly deals with the contents. So yes, your contents may be approved accordingly. You may have got the certificate of your content, but how and when and in what form post publication will be affected, how it is governed.
Your,
Certification rules, every advertisement of a certified film, whether poster, hoarding, handbill or trailer, must display the certificate and title of the film. That is Rule 38. So it do not deal with the actual fact that the trailer is certified.
Your Lordship, in the last line it has been.
The CPMC certifies the trailer. It merely says that while you are making a trailer or any other advertisement, your certification should be mentioned.
Yes, Your Lordship. Yes, Your Lordship. However, it has been stated also that it has to be inserted in other materials like trailer. And additionally, as I explained, that in Times of India, it has been stated that when a movie named Leo, the trailer of that movie was released without because of uncertified trailer, it was the CBFC who took action. And this again.
See, your point is that once CBSC certifies, there is no requirement of a parallel certification
Your
by the
Lordship.
state.
Yes, Your
But
Lordship.
when you approach the High Court, did you challenge the ban only or did you challenge the state law as well, saying that the state law cannot prevail in the same domain where the central law is already there? Did you challenge the acts, the state act, or you challenge only the ban? What did you challenge before the High Court? Because if you did not challenge the act before the High Court, we as an appellate authority, we cannot go into that question because the first forum has not looked into that question. So you first say before the High Court, did you challenge only the ban or you challenge the ban as well as the act? It should be there in your moot problem itself.
Your Lordship, it has been merely stated that the High Court have considered.
See, your case is that the producers of the film aggrieved by this ban
Yes.
filed a writ petition under Article 226 of the Constitution of India. So you did not challenge the act. You accepted the jurisdiction of the act. Once you accept the jurisdiction of the act, you must follow the procedure under the act. You have not asked for a declaration of the ultra vires of the act because CBFC certification is already there.
And another thing, your main concern is pertaining to ban, not the content. Whatever you are stating, Rule 38, it deals with the certification of the contents.
Yes, Your Lordship.
And the dispute here, the moot question today arising is whether the ban, that is post publication or after a film has been made at its publication stage, if it is banned, then whether it is allowed or not, that is the moot question. Post publication, right? So if we are not dealing with the content, are we dealing with the content? You are telling about 38. 38 deals with the content, the certification for the content.
Yes, Your Lordship.
But we are not here with the contents, right? We are not dealing with the contents.
Your Lordship,
film.
the content. Yes, Your Lordship. Your Lordship, the trailer, the whole reason of bringing the trailer was that the intervention was done on the grounds that the trailer was uncertified under the State's Publicity Material Act. However, even in the State Publicity Material Act, the term trailer has not been used, and all in the nationwide, it was always under the central regime that certifies the trailer. So when when a act which derives its authority from entry 33 list 2 has clearly been stated that it is subjected to entry 60 list 1, Your Lordship, after this, the state do not have the right to encroach upon the central regime in terms of certification. And the Rule 38 over here presents that it is under the central regime.
But state is probably not intervening with the content. They are not intervening to the content of the publication because you are already certified.
Yes, Your Lordship.
Yes, for the content, but for the publication,
Your Lordship,
state is harping on publication. That whether you have the requisite permission or certification to publish that.
Your Lordship, the way a film has been certified, it means that it will be exhibited. Similarly, when a trailer is certified by the CBFC, it means that it will also be exhibited. Your Lordship, intervening a trailer launch even on the mere grounds that trailer has not attained a parallel certification from the state law is vague.
What is the, according to you, what is the purpose of a trailer?
Yes.
And even if that be so, they are not in the publicity. They are on the certificate.
Court officer, this is 1958 rules. What you have given us is 1958. So what according to you is the purpose of the trailer? That is what I wanted to know. What do you think according to you?
It is also a artistic expression, Your Lordship.
It is
an-
not
a
not
part
for
of the
giving
film.
publicity. The trailer's purpose is not to give publicity. Is the purpose of the trailer to give publicity, or is it a independent artistic expression in a audio visual mode?
Your Lordship, yes, it is for the promotional aspects
So
also.
if it is for the promotion, why is it not publicity material under the 1974 Act?
Yes, Your Lordship, the definition of 2G has clear, the definition of 2G has not included the term trailer. Additionally, if even if we consider
Doesn't matter, it says for any material for giving publicity, and it includes. It is not restricted to, it is includes. So when it says includes, we'll have to understand that. Yes,
Your Lordship,
whichever is necessary for giving publicity.
The rule of egestem generis shall apply. Getting my point?
yes, Your Lordship, Lordship in
We
unit.
cannot be oblivious of the fact that in 1974 trailers were not that much a thing, which is now. This act was in 1974. Then artists used to have one album in the year which used to come out in the puja. They were not in the era of trailers and Instagram stories. So we'll have to understand the definition in that background also, and we'll have to give it an appropriate definition in today's circumstances. That is the job of the Supreme Court, right?
Yes, Your Lordship.
Okay, carry on.
Your Lordship, the Bongo Pradesh Publicity Material Act 1974 is penal in nature, and even if we consider that it was
Why it is penal in nature?
Your Lordship, Section 8 prescribes punishment and imprisonment and fine, thereby making it penal in nature, Your Lordship.
Okay.
So when a statute is penal in nature, Your Lordship,
We'll go for strict rule of interpretation.
yes, Your Lordship. And therefore, when the term trailer has not been used in Section 2G, the wide interpretation will be against the.
No, we can do that by applying the rule of egestem generis. We can do that. Yeah.
Egestem generis is evaded only if there is a non-obstante clause.
Your Lordship, it also has the term means and includes, and it can be narrowly when it is of a penal statute, it is a penal statute. Additionally, it has the term of means and includes, and it has never been that the trailer requires a parallel certification that is encroaching the central
Bench is
regime.
clear on its decision. You please carry on with your next submission.
Yes, Your Lordship. The action of the police is arbitrary and violates Article 19(1)(a).
Let your researcher know in the meantime, your 1983 rules have been repealed by a 2024 rules of 15 March 2024, and the law governing the field is cinematograph certification rules 2024. So 1983 rules have no existence as on date. I am only letting the researcher know about it. So you will not rely on that rule because it's not there.
Lordship.
Carry on with your next submission.
Your Lordship, when the term expression is used under Article 19(1)(a), it also includes or the artistic expression, which means it's trailer also. Your Lordship, 19(1) in S. Rangarajan was a Jagjivan Ram. It has been clearly stated that Article 19(1)(a) can only be restricted under Article 19 Clause 2. However, Your Lordship, when a trailer launch event was interrupted on the grounds that the trailer was uncertified, the reasonable restriction under Article 19(2) was not fulfilled, because there was no, even not a mere apprehension of public disorder or any of such matters, and therefore the police intervention in such matters should be considered to be arbitrary. Your Lordship, even it has happened that a uncertified trailer be launched and or shown, and CBSE shows a show cause notice. It does not intervene, it does not disrupt the event, and the state could have went on with a show cause notice rather than interrupting and disrupting the event.
Does the Act provide for a show cause notice? Section 6,
Of the state law?
the state law. The action is under state law.
No, Your Lordship. Your Lordship, when the center follows the rules that it certifies a trailer, and when that trailer is not is uncertified, then it presents a show cause notice. Isn't it like the state law has made it a cognizable offence, a penal provision?
You have S. Rangarajan
Yes, Your
in
Lordship.
the compilation, your compilation.
Yes, Your Lordship.
Please take it out.
Yes.
Go to paragraph 45.
Your Lordship, my compilation did not have the para 45.
I'll read it for you. Para 45. The problem of defining the area of freedom of expression when it appears to conflict with the various social interests enumerated under Article 19(2) may briefly be touched upon here. There does indeed have to be a compromise between the interest of freedom of expression and special interest, but we cannot simply balance the two interests as if they are of equal weight. Our commitment of freedom of expression demands that it cannot be suppressed unless the situation created by allowing the freedom are pressing and the community interest is endangered. So do you think that state was wrong in taking an action when the community was endangered by violent actions, as we can see in the facts? And is your right under 19(1)(a) absolute?
Your Lordship, is it regarding the trailer launch event, the intervention in the trailer launch event,
We are on the ban.
on the film ban?
Yes, because you just referred to S. Rangarajan.
Yes, Your Lordship. It was for the trailer launch event that a trailer is also an artistic expression, and it also is.
But the action was
protected.
taken after the movie was released in July, right?
Your Lordship, it was regarding the police intervention being
Yes.
arbitrary.
So when the action is endangering the community, these mob actions, etc., was the state, according to you, unjustified in imposing a ban?
Your Lordship, that is. Yes, Your Lordship. Yes, Your Lordship. Yes, Your Lordship.
We can postpone our question to your colleague. There is no problem at all. if you want to answer only after the trailer, we'll postpone our question to your colleague.
Your Lordship, I request to rephrase the question. I will try to answer the question.
No, it is difficult to rephrase, but the overarching point you can answer whether you are right under 19(1)(a) is absolute or not.
Your Lordship, it's not absolute. It can be restricted under Article 19(2). However, it has to follow the test of, it has to clear the test of reasonableness.
So my
And-
brother asked the petitioner this question, that what is your test of reasonability then?
Your Lordship,
Because we already found their answer, we want your answer, we can fit the two answers together.
Your Lordship, action will be considered to be reasonable when it fulfill the conditions of Article 19(2). That it has been stated that the expression can only be restricted when there is a chance, where there is a possibility of public order, decency and morality, and there is incitement of offense or defamation. Your Lordship, in the present case, there is a mere apprehension of obscenity and defamation. There is no conclusive proof about the same. Additionally, the public order, even though there is a violent public order, there can be taken a less restrictive manner than that of a unilateral ban. And the ban, because it was unilateral, it was a blanket ban and was disproportionate, and therefore it does not follow the test of proportionality, and neither it is reasonable.
I think we can move on to the next speaker. I think
Yes, Your Lordship. No, Your
One more last comment. Like, if you look at page number 2 of your memorial, you've mentioned in 2.3, the action of the police is arbitrary.
Yes, Your
Balance
Lordship.
to Article 19(1)(a).
Yes, Your Lordship.
How do you substantiate your claim?
Your Lordship, trailer also come under Article 19(1)(a), the term expression. Yes, Your Lordship. It could have been the restriction need to be in Article 19(2), not the intervention. Your Lordship, in Indibly Creative Private Limited was the state of West Bengal. It has been stated that the police in a free society are not self-appointed guardian of public morality. Your Lordship, in
What is morality? How do you define morality? Public morality. And then we'll come to public morality as well. Severe level of public morality. Let me finish this. We have time. One more minute.
yes, Your Lordship.
What is the relationship between morality and law? You're claiming that the police is doing immoral activity. You have to explain what is immoral and very considerable. Okay. Okay, no. Fine. Yes, yes, I'll explain you this before.
yes, proceed, please.
With the due permission of your Lordship, the Council shall proceed with the third issue.
Proceed.
Much obliged. May it pleases the Honorable
court, the third issue is the ban imposed by the state government on the exhibition of the film within Bongo Pradesh is invalid under Article 19(1)(a) read with Article 19(2) of the Constitution of Sindhia. The Council of Respondent humbly submits that the ban imposed by state government constitutionally invalid under Article 19(1)(a) read with Article 19(2) of the Constitution of Sindhia. In support of this submission, Your Lordship, the Council has bifurcated the arguments into three parts. Firstly, the ban directly violates the fundamental rights of freedom of speech and expression under Article 19(1)(a). Your Lordship, the Council seeks permission to draw your attention on page 22 of the compendium, para 5. Your Lordship, in Nacheketa Valhelkar versus Central Board of Film Certification, the Supreme Court recognized that the film, like a book or a painting, is a creation of art, and the artist enjoys the liberty to express his thoughts in a manner that is not prohibited by law. The court observed that a film need not to be didactic or periodical. Under Article 19(1)(a), Your Lordship, the filmmaker possesses the freedom to present his ideas in a form that may not necessarily align with the majority's view. What is essential is the protection of his creativity and intellectual liberty, Your Lordship, not its suppression based on subjective notions of morality or anticipated public disapproval. Secondly, Your Lordship, the restriction imposed by the state do not satisfy reasonable restriction under Article 19(2), Your Lordship. For the further clearance, the argument 3.2 is further bifurcated into three parts. Public order cited without justifiable constitutional basis. Secondly, decency and morality invoked beyond constitutional justification. Thirdly, misplaced reliance on defamation as reasonable restriction. Obliged to Your Lordship, as it pleases Your Lordship. In K.M. Shankarappa Union of India, the Honorable Court held that once the expert body, after analyzing the impact of the film, has cleared it for public exhibition, no excuse for a violation of law and order can be taken by the state. It was clearly observed that it was the duty of the state government to maintain law and order in the state rather than curbing the exhibition of a duly certified
Which
film.
case study you're referring to?
Your Lordship, Union of India versus K.M. Shankarappa.
Page number?
Your Lordship, page number 21 of Moot Memorial and page 22 of Compendium, para 8.
The Shankarappa versus Union of India, not vice versa. It is K.M. Shankarappa versus Union, not Union of India versus Shankarappa.
Your Lordship, actually there is two cases, K.M. Shankarappa versus Union of India. The case we are cited here is Union of India versus K.M. Shankarappa.
Citation? Which one?
Your Lordship, it has been mentioned in the compendium, page 22, para 8.
No, in the memorial?
In the memorial, Your Lordship, page 21.
91. Para 35.
While citing any judgment, always give the citation.
35, para 35.
Yes, Your Lordship.
That is Shankarappa versus Union of India. Furthermore, in K.M. Shankarappa versus Union of India.
The council seeks pardon, Your Lordship. The case is K.M. Shankarappa versus Union of India.
Yeah. Carry on.
The Honorable Supreme Court here held that once the expert body, after analyzing the impact of the film, has cleared it for public exhibition, no execution for a violation of law and order could be taken by the state. The state cannot substitute its own subjective satisfaction for that of the expert body constituted under law, and must instead discharge its constitutional responsibility to protect freedom of expression, Your Lordship. Secondly, decency and morality invoked beyond constitutional justification. The concept of decency and morality under Article 19(2) are inherently relative and cannot be merely subjective to the notion or moral sensibilities, Your Lordship. Your Lordship, the Council seek permission to draw your attention on page 24 of the compendium, first para, the case of N. Radhakrishnan versus Union of India. The court held that it is the duty of the court to determine whether the dialogues or scenes were contrived to give rise to an indecent or humiliating situation or whether they are simply a part of creative expression. Thus, the scrutiny of whether a work offends decency or morality must always rest with the judiciary based on a rational and contextual evaluation.
What is
Your
the
Lordship.
citation of the case you're just referring to?
Your Lordship, N. Radhakrishnan versus Union of India.
Yeah, what is the citation there? Like, look at the reference, like in which SCC or what?
Your Lordship, the Council seek permission for 2 minutes.
What? You have the compendium with you?
Yes, it is in the compendium itself, Your Lordship. Yes, Your Lordship. In the compendium, the citation is SCC online. Sorry, Your Lordship. The extract is taken from N. Radhakrishnan. It has been mentioned in compendium page 23. The extract been taken N. Radhakrishnan versus Union of India 2018, 9 SCC 725, 2018.
See, 2018, I've been trying to make you understand the entire idea of decency, morality changes over time.
Yes, Your Lordship.
I will help you to understand this by citing one example. There was a case, which of course is an intellectual property case, where a person found out that a particular movie that he just saw was something very similar to a novel that has been written by his own father. He went to have a look into who is the copyright owner and found out that it's a complete new person. He challenged this matter before the court, and it was unraveled that this matter was requested by his father at one point of time to get a copyright, but it was not given a copyright because it involved the story of a lady with multiple number of extramarital relationships. But later on, when the filmmaker and the story makers of this particular film went to get a copyright, they got it. Because the idea of morality have changed over time. So try to come up with a case study which is of recent origin when you're talking about things like decency, morality, and ethical standards.
Probably your citation is wrong. You will later check it. It should be 2018 1 SCC, not 9 SCC.
Council seek pardon, Your Lordship.
Even the other citation is wrong. I just checked myself. That yes. I hope these are all not AI generated.
The Council seek pardon for this mistake, Your Lordship.
You are not, you all are, what you are doing is you are not citing the ratio of the judgment. You are taking certain points what the council submits and certain things which the judge thinks, but not the ratio in the judgments. Okay.
A ratio here means you have to come into a particular comparison between the case that you're citing and the case that is there in your hand. And then you look into the principal similarity and dissimilarity ratio. Okay? More the similarity, more relevance
See, a
it becomes
judgment
for
is
this
reported.
case.
Once it is reported means it becomes a precedent. That means the facts, irrespective of the fact, it becomes a precedent. You cannot pick and choose and say that hence it is precedent of a judgment.
Your Lordship, the Council seek pardon for this mistake. The Council seek permission to proceed with the next issue. Much obliged, Your Lordship. The ban amounts to arbitrary exercise of power and fails the doctrine of proportionality, Your Lordship. The state here opted for a sweeping measure affecting the entire public domain, which was unnecessary and disappropriate to the situation. Here, the council seeks permission to draw your attention on compendium page 27 para 15 in Prakash Jha versus Union of India. The court clarified that suspension implies a temporary halt and not a complete prohibition. By imposing an outright ban or a blanket ban all over the state shows that the action is disproportionate, Your Lordship. When the ban of the movie was declared by the state government, they didn't give any notification about its temporary or when it will curb the ban. Even under section 6, the state government after 2 months can increase the declaration in its own discretion, Your Lordship, thereby creating an uncertainty for the rescreening of the film. Your Lordship, here the ban that has been imposed by the state, the notification of the ban is not given to the respondent here, that is to the filmmaker. Sorry, Your Lordship. Your Lordship,
Have you read the provision of the Act?
Your Lordship, the State Act, that is...
Yes.
Yes, Your Lordship.
Has there been any provision with regard to giving the other side a notice?
No, Your Lordship.
Your counterpart argued that this is a penal provision. This is a penal statute. So in a penal statute, so will the police will also go and give a notice to the accused that I am coming for you?
However, Your Lordship, if such rationale is used in our case...
No, you have used the rationale. We are not using it. We are only drawing the analogy here.
Your Lordship, the producer in the filmmaker suffers if the ban continues for a long period without...
That's a different thing. My senior brother is asking for the show cause, not the time limit of the ban. That was a different question asked to another person. Notification of the ban, he is asking whether it's required under the statute or not.
Your Lordship, it is not required under section 6. Your Lordship, if the ban exceeds, it can cause a great harm to the producer.
And we appreciate that. But with regard to the notice,
Your Lordship, the ban was blanket, and that the ban was temporary in nature.
can there be a ban which is not blanket under the provisions of this Act?
Your Lordship, the Council seeks permission for 2 minutes.
How you define temporary? Is it defined anywhere?
Sorry, Your Lordship.
Another statute,
Pardon,
is
Your
it?
Lordship.
Temporary, you are telling temporary, you are submitting temporary. Where is it defined?
Ban
Under
should
the
be for
statute?
how long? According to you, the ban should be for how long? Maximum time?
Sir, Your Lordship, it depends on the situation.
Okay, so there is no time limit mentioned. That's a fair submission.
That is the
So
only
far everyone is
submission.
submitting 2 months, someone is saying 15 days, someone is saying 6 months.
Where is the law? Nothing of that sort.
At least you have submitted that it is depending on the situation, the ban will be there. We also find that it's the same situation from section 6.
So that means the temporary might become never ending.
Never ending, and it can endanger the right of the filmmaker.
So of course that is the reason
So
why
have
you are
you taken
pleading.
the plea of ultra vires of this? You have not.
Sorry, Your
And
Lordship.
that needs to be
Pardon,
addressed.
Your Lordship.
No, have you taken any defense on that? Have you controverted? Have you taken the plea of ultra vires of this part of the act itself?
You have not challenged the act before the High Court. That is what my learned brother is saying.
Yes, you
not
have challenged the
act.
vires of the act. Have you challenged?
You have come to a state to make a movie, not come to a state to make a movie. You want your movie to be released in a state which coincidentally has the 1974 Act. And under the Act, a particular certification is required. It may not be required in Tripura. You go and release the movie in Tripura. The requirement may not be there in Goa. You go and release the movie in Goa. But if you want to release the movie in a state which has a particular act, without challenging the virus of the act, how can you say we will not follow that act?
See, every state has its own set of culture, and history determines that culture. And it is the purpose of law to protect those culture and the various issues therein. Okay. Now, if you have a question in furtherance of this particular ban, coming back to this particular case, and say that a ban cannot be eternally there, this court does have the power to vacate that ban. But for that, you have to mention the reason on the basis of which the court will grant that particular order in your favor. There have been questions on the authenticity of the facts that has been highlighted, which prompted a lot of things. Things could have escalated. The police took an action of a blanket ban without giving a notice, because the notice is not there as a mandatory requirement under this act, even when a notice by itself, if it is not criminal in nature, requires the principle of natural justice to be adhered with. But for that, even when the 5-judge bench gives the power at this moment, but for that you have to come up with a separate application to deal with the constitutionality of the provisions of that particular state act. But you have not done that, hence we can't work on that particular point as of now. Are you getting the points clear?
Yes, Your Lordship.
Now you come to your next point. I think you raised 3 points in furtherance of this, and you have dealt with 2 of them. Now you come to the third one.
Sir, Your Lordship, that is the defamatory one.
Yes.
Your Lordship, the mere fact that certain section of public may find the depiction uncomfortable does not render the film defamatory. And here in the moot proposition, it has been mentioned that there is a mere allegation of defamation. Your Lordship, in the case of Babuji Rauji Shah versus S. Hussain Zaidi, the Honorable Supreme Court held that the certification issued by the CVFC prima facie.
Before you move into the citation, I just want to ask one thing. Talking about defamation, how many types of defamation are there and what is applicable and valid in India? Like, there is libel and slander. So, talking about defamation, which part you are talking about? Whether it is tenable in law in India?
Here,
The
Your
ambit of defamation is huge. Please.
Here, Your Lordship, the ambit of defamation has been used on the basis of a mere allegation.
I got your point. If someone is leveling that a defamatory statement has been made, whether that leveling or accusation upon you that you have used certain thing which is in defamation, is it tenable in law?
It is not. As a matter of fact, defamation depends on certain factual conditions, and this is not the court that deals with the facts.
Your Lordship, in the present case, the respondent film has already been granted certification by the CVFC after thorough scrutiny. Therefore, the subsequent claim of alleged defamation by the state based on mere allegation raised by certain community groups is wholly unfounded and amounts to an unreasonable restriction, Your Lordship.
Okay, okay.
Your Lordship, the Council seeks permission to proceed with
Next
the fourth
issue.
issue.
Yeah.
Much obliged, Your Lordship. Your Lordship, the Council of Respondent humbly submits that the state government under the West Bengal Cinema Regulation Act 1954 does not possess the authority to override or supersede the certification granted by the CVFC. Your Lordship, the supremacy of CVFC certification...
No, you have not finished that particular part. You please finish.
Your Lordship,
Particularly in extraordinary circumstances where law and order,
order
is
is
at
at stake. Supremacy of
In
certificate.
this case, law and order was at stake. Right? There have been chaos, there have been issues happening, people have come up unnecessarily because of one film, which is of like many years back. It's fine if the state decides to stop that.
Your Lordship, it is the positive duty of the state to control the public uproar, the public disruption, or the mob intimidation that has been caused by the public.
So do you agree that public order, we have discussed entry 60 in list 1, entry 33 in list 2, but will you agree that the public order is list 2 and is state subject? So irrespective of the fact that who certifies the film, public order, including law and order, is a subject matter of the state, because we are West Bengal, this Bongo Pradesh is not a union territory, so it is their subject matter. So if it is their subject matter, the policy should rest with them. Why should we read entry 1, entry 60 in list 1, entry 33 in list 2, divorced from entry 1 of list 2, which is the public order?
Your Lordship, entry 33 list 2 is subject to entry 60 of list 1.
That is entry 33. But public order, which is entry 1 of list 2, that is not subject to any other provision. So every state has within its domain the public order, including law and order.
Public order is there not in list 1 or in list 3. Are you getting my point?
Yes, sir.
So it is completely within the jurisdiction
Of the state.
of the state.
Why should we snatch it away from
And
the
the
state?
state has used that particular thing in furtherance of the law provided by the constitution. You are trying to say that this has not been done correctly. And if you have the right to say that, subject to you show exceptional scenarios.
Your Lordship, here the state has failed to perform its duty. It is on the discretion of the...
You are merely alleging without a substantial proof in your favor.
Your Lordship, in the case of ICOM 18 Media Private Limited and another versus Union of India and others, it was emphasized that the parliamentary legislation confers responsibility on the statutory board, and once the board grants certification, any prohibition on exhibition by the state would be contrary to the statutory provision and would infringe upon the fundamental rights of the claimant.
Which state was there in the response? Is it West Bengal? Or the one which is pari-materia with West Bengal?
No, Your Lordship, I would like
All
to...
states have their own distinctive set of rules and regulations which is vested on them by law.
Your Lordship, the Council seek permission to cite another precedent that is related to the West Bengal. In the case of Indemnity Creative Private Limited
Which
versus...
page number of the memorial?
Your Lordship, memorial page number 25.
Para number?
Para number, Your Lordship, 52.
Okay.
Your Lordship, Indemnity Creative Private Limited versus Government of West Bengal, the court held that any excess or abuse of statutory power by the state
There
is-
has not been any excess of statutory power. The statute specifically provides this. Now, do you have any? Do you have any proof that there has been an excess or abuse?
Your Lordship, in the flame of indemnity, the Constitution does not permit those in authority who disagree to crush the freedom of others to believe, think and express. The ability to communicate ideas is a legitimate area of human endeavor and is not controllable by the accessibility of the views to those whom they are addressed. When the ability to portray art in any form is subject to extra constitutional authority, there is a greater danger that fundamental human freedoms will be impaired by a cloud of opacity and arbitrary state behavior, Your Lordship.
I completely agree with the case law that you just cited. My question is, does the compendium highlight any specific provision or factual position referred to in this particular moot proposition which explains arbitrariness on the part of the state? Absolutely, yes.
Pardon, Your Lordship?
Or whether any abuse has happened or arbitrarily the power has been exercised. We completely appreciate the case law that you have cited.
Your Lordship, the state, in the present case, Your Lordship, the state is not preventing the heckler's veto, as the state silenced the freedom of expression of the filmmaker due to the protester.
But there has not been any excess or abuse of statutory power. Or do you want to say that what the state has done is basically an abuse of statutory power?
No, Your Lordship, it is the positive duty of the state to safeguard expression against intolerance and censorship, Your Lordship. Pardon, Your Lordship? When the right has been curtailed, that showcase that there is an abuse of power, statutory power.
See, you are addressing the Supreme Court, right? So whatever we are conscious that whatever decision we come to will not only apply to Bongo Pradesh but the entire country. So we'll have to pitch our thought process in that arena, right? So as a council, you tell us that where should Supreme Court draw the line of this balance of freedom of expression and the restrictions in 19.2. In your given facts, you give us a suggestion to the bench. We'll consider when we consider the entire things. Because we are also conscious whatever we say will not apply to Bongo Pradesh only. We'll have to think about the entire country's law and order, maybe not for your film, but other films also. So you give us a suggestion that where do you think the line should be drawn? Because you are here as a lawyer, you are an officer of the court, so we are asking this suggestion from you.
Your Lordship, under Section 5B of the Cinematography Act 1952, it grants power to the Central Board of Film.
Forget the act. Where should the line be drawn? We are here to, whatever we say, that if we say that yes, no matter how the history is distorted, it is allowed if CBFC allows it. But there has to be a line drawn, because it is, your colleague has said that 19.1A is not absolute, it is subject to 19.2. So Supreme Court's duty is to create that balance, that line, thin line, where the freedom will also be there, restriction will also be there. Where do you think the line should be drawn? Yes, in between freedom and restriction, so that none of them are disbalanced.
council seek permission to rephrase the question, Your Lordship.
The reasonableness. Can you tell us the reasonableness where the freedom will not become absolute? The reasonableness where it can be restricted. Reasonability, when you can restrict it. When you will call, yes, these things, if it is violated, then it is restricted.
Where will we ask the people of the country to stop? When will, there has to be a line, there has to be a determinative factor. Just because CBSE has allowed something to be publicized or published, that does not mean we can go allow the law and order of a state to go to the rods. Again, we cannot give the unlimited power to the state governments to say that any film, I'll stop any film because 10 people are agitating. So a line has to be drawn. That was my question, but it's all right.
One response to this question could be, this is just a suggestion. It depends on the facts and circumstances of the case. This is one response
Yes,
which you
yeah.
think can answer this
Yes,
question.
Your Lordship. It
Or
depends.
you can have other options as well. Okay, next. Your time is more or less done. I think you can
Yes, Your Lordship, the council seek permission. If the bench is satisfied with the above argument, the council seek permission to proceed with the prayer, Your Lordship. Much obliged. In the light of the argument advanced and the authorities cited, the counsel for respondent most respectfully pleads before this honorable court to hold the present appeal is not maintainable before this honorable court, hold that the state government of Bongo Pradesh has acted unlawfully in preventing the trailer launch event in the light of uncertified trailer, hold that the ban imposed by the state government of Bongo Pradesh is constitutionally invalid, affirms the primacy of CVFC certification, and hold such certification cannot be overridden by the state government, and pass such order as this honorable court may deem fit. And for this the act of justice, the respondents, as in duty bound, shall ever pray. Much obliged, Your Lordship.
With a lighter note, I just want to ask, if they want to apply for a leave to withdraw, do you have anything to oppose to that? If yes, why? If no, why?
Your Lordship, can I ask my co-counsel to answer the...
If the petitioner withdraw the leave, the respondent would not have any issues, Your Lordship, because the ban has already been considered to be unconstitutional in the High Court of Bongo Pradesh, and therefore there would not be any opposition from the respondent.
So respondents are happy that they have delayed, they have undergone such an hassle to the court, paid so much money to the council. Respondent is okay with that, I believe.
Your Lordships, my learned opposition counsel has cited the Cinematograph Act under issue 2. The Cinematograph Act clearly deals with the cinemas. A trailer is not a cinema. The act having the purview over such matters is the Bongo Pradesh Compulsory Certification of Film Publicity Materials Act of 1974, under which Section 6, subsection 3 says, no producer, distributor or exhibitor can display any film, publicity material without getting a censorship certificate under this act. And then again, under section 8A of the same act allows any police officer to enter, search and seizure any publicity material that has not been certified under this act. Shall I move to my next question? Yes, Your Lordships.
But trailer is very well included under the Cinematography Act. Why you are submitting it is not included?
Your Lordships, they have cited the case of Prakash Jha. I would like to cite the ratio of the judgment. In the case of Prakash Jha versus Union of India 2011, the Supreme Court held that CBFC certification does not immunize a film from temporary state restrictions imposed to prevent public disorder. And they have also mentioned that the state have failed to restrain public order, and it's the state duty to restrain public order. And in such notion, such authority only to restrain public order, the ban has been imposed. So under which question the opposition council can question it?
So you want to mean that the judgment cited by them is against the natural.
Come to 5B of the
For-
Cinematography Act. Can read it.
Pardon, Your Lordships, currently we lack the statute.
5B. Okay.
Currently we lack the statute.
Cinematography Act. Cinematograph Act 1952. You have the act with you.
Currently we don't, Your Lordship, we pardon.
Acha, okay, I will read for you. 5B1, a film, principles for guidance in certifying films. A film shall not be certified for public exhibition if, in the opinion of the authority competent to grant the certificate, the film, or any part of it, which includes everything, any part of it, is against the interest of the sovereignty and integrity of India, the security of the state, friendly relations with the foreign states, public order, and so and so.
Your Lordship, a trailer isn't a
So-
part of the film or the film itself.
Where
It
from
is-
we can get that?
As my co-counsel has previously stated the fact, in a very recent judgment of Yash Raj Films Private Limited versus Afrin Fatima Zaidi 2024, it has been taken into account that trailers does fall under the purview of 2G of the Cinemas Regulation Act, State Cinemas Regulation Act, and will fall under the Aegis Done Generis principle.
How? Then you are contradicting yourself. On one hand, you are telling that it will not fall, and you are citing a judgment which says yes, it will come.
Your Lordship, it will fall under the regulations of the Censorship Act, not the Cinemas Act.
Where from we can get it?
Your Lordship, the statute has been provided to you.
Yes, where it is stated, in the statute where it is written. Show me
Section
what-
2G.
No, from the
Publicity material.
Cinematography Act, where it is written, it will not be governed.
The mere in its description clause.
First comes the Central Act, then the State Act.
Indeed,
Based
Your
upon the Central Act, a State Act is formed.
Indeed, Your Lordship.
Which one will prevail?
The Central Act in such cases, though the state has the authority to maintain its public order in some cases. Your Lordship.
Obviously, but will it deviate from the Mother Act? The
Your
intent of legislation has to be understood.
Your Lordship, my co-counsel has the expertise on this matter. May I call my co-counsel to answer the same? Much obliged, Your Lordship.
Lordship, could you kindly again read section 5B of the Cinematograph Act?
Principles for guidance in certifying films. 5B1, a film shall not be certified for public exhibition if, in the opinion of the authority competent to grant the certificate, the film or any part of it is against the interest of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, and such and such. I am not reading the entire thing.
Your Lordship, Cinematograph Act, the Central Act is dealing with certification of films. Certification and censorship are two different subjects. Certification under Section 5A of the Cinematograph Act, it is dealing with whether a film is to
Certificate of what?
certification of the film. The
Then
film is to
censoring
be
of what?
I'm coming to
When
that.
is censored?
Yes. Certification of film under Section 5A is dealing that whether a film is to be considered, given the certificate of universal adult, like that. But the State Act is dealing with the censorship certificate. Because that censorship certificate was not been taken by the respondents, that is why the police had intervened. The very purpose of both the acts is different. That is why there is no question of clash between these two acts. Yes. Your Lordship, as per my interpretation, certification under Section 5 of the Cinematograph Act is dealing whether a film is to be considered an adult movie, universal adult, or universal or special. And censorship is when the committee is considering if there is any particular scenes, any particular thing that has to be censored. Your Lordship, under censorship, before the exhibition of the... Your Lordship, please correct me if I'm wrong. For censorship, before exhibition, the censored scenes are removed. But in certification, the act is clearly laying that this is the audience who want to watch the film. This is the universal audience, adults or children, or universal adult, like that. So certification is clarifying that this is the suitable audience, whereas censorship is completely removing those particular scenes which are censored.
So you are trying to say that the CBFC is certifying the content of the movie?
Yes.
And under your act, you are trying to certify the publicity material which is being published in aid of that film, because the movie may be only for the adult. But when on the street everyone is moving around and looking at the publicity material, the publicity material should not be obscenic, because we cannot control that. A kid will also watch that publicity material.
Yes, Your Lordship.
So CBFC is saying that it's an adult content. In the cinema hall only adults will go. But the poster should not have something which the child will also see.
Yes, Your Lordship. That is
So
why
the domain is different.
That is why the censorship certificate is needed under the State Act.
Correct. So that is, if I
So my
understood this
question
correctly.
is, then which one has an overriding effect? Which will prevail upon the other?
Lordship, if the very purpose of both the act is different, then why will be there a clash between the two acts?
So that is the reason I am asking. What is the intent of legislation?
Of the States Act.
Yes, of both the acts. Can it deviate from the central act? If the intent of legislation according to you is same, then can a state act deviate from the central act?
No, Your Lordship, I am saying that the intent of the State Act is different.
You are submitting it is not same. Intent of
Yes.
legislation is different.
Both the acts, both the purpose are different. State's legislative intent is different and the central's
Acha.
intent is different.
But they're applicable on the same thing.
No, the States Act is applicable on the publicity material and the Central's Act is applicable on the film itself. Much obliged, Your Lordship.
So according to you, any state act can be sui generis for that state.
Pardon, Your Lordship.
Any act for any specified state may be sui generis to that state irrespective of the central act.
But Your Lordship, if a question has to come between clash of the two acts,
Yes.
then there must be clash
Which
between
will
the
prevail?
provisions of
Which
the
will
two.
prevail?
If there is a clash, then the central will prevail. But in this matter, issue number 2, there is no question of clash between the two acts. The very purpose
Why?
of both the act is different.
How?
Because the Central Act is dealing with first certification and of films. States Act is dealing with censorship certificate of publicity materials.
Thank you.
Much obliged, Your Lordship.
Lastly, I have the whole team of the petitioners. What are the object of your petition or such a petition? What is the object of your
Lordship, the petition has been filed to address the substantial question of law, that is, what is the balance between free speech and where the reasonable restriction grounds come into it, and to restrain the public order, which is...
Your Lordship, I would, from the petitioner, the main objective is to maintain the law and order within the state. That's why that's the main purpose of this act. So,
Your answer.
Your Lordship, as has been stated under Article 136, the substantial question of law. Now, if the substantial question of law is the balance between free speech and public order, if this particular question is not being solved, then this question will recur.
But I want to ask one thing. See, this is a. Achha.
The main objective was to nullify the High Court's order. You have come before the Supreme Court to set aside the judgment of the High Court. You have never mentioned it. Then where the High Court went wrong, and that's why you want to correct it. Why the appeal? You have not mentioned in your writings and you have not stated in your argument. The judgment of High Court, you have to assess that. By killing the judgment of the High Court, you can win in Supreme Court. Isn't it? Where have you mentioned that?
The council seeks 1 minute. Where is the memorial?
Your Lordship, though we have not expressly mentioned it, we have implied that the state ban was constitutional in nature. Your Lordships, the High Court judgment never mentioned about the maintenance of the public order. It only stated that the state cannot poses a ban when unilateral...
Before I ask you, you have mentioned that where the judgment went wrong. Next time remember that. But what are you challenging? You will face many other rules. You have to target that. But this is where the High Court went wrong. And that is why we want to rectify that. So I have come before you. That should be the approach of our appeal.
Followed, Your Lordship.
And very rightly, my brother has said, senior brother, even in your prayer, nowhere you have written to set aside the judgment of the High Court. Right? And see, this is a constitutional bench. So, we all are here. Our main purpose is harping upon natural justice. Right? So, Audi alteram partem and nemo judex in causa suo are the basic fundamental pillars of natural justice. Yes, you have spoken about censorship and everything. So, being a state and utilizing your state machinery, have you not jeopardized the right of the petitioner in the court below without giving him a chance, without any notice? Someone comes, barges and bans. So don't you think that natural justice has been violated?
Okay, so we move on to the next rebuttal question. If you have any
And
responses
in your memorial, page 16, 1.2.3, his sir's answer is there. You have not read your own memorial. You read it in the evening after the competition. 1.2.3, you have answered it, but you could not answer to sir.
Anyways, any responses from that side? Thank you. You can take your seat, please. Please.
Your Lordship, the counsel for the petitioner contended that the case Prakash Jha was miscited and misrepresented. However, in a memorial, Prakash Jha was mentioned to explain the term suspension, which is temporary halting. The Section 6 of the Cinema Regulation Act, Section 6 of Cinema Regulation Act of the state was explained, and one of
Okay, got it. We are happy with your answer. Now, any other question that you'd like to raise? Okay. Thank you. Okay, so we have heard both the sides, and we'll take a couple of minutes to decide on the merits of this particular matter, and they'll get back to you in a couple of minutes.
The request of the Bhaskar sir, a few lines for the contestants. You are all good, trying very hard. You all tried very hard. Just don't get nervous by your questions. Next time, just keep your head, keep a cooler head. Take a second, take a pause, and then answer it. And move on with your one. Don't stop. don't go for the headlines. Read the full body of the judgment. Otherwise, you shall be fooled. Every judge sometimes do that mistake and learn from it. Every lawyer makes that mistake and learn from it. Go through the full body of the judgment before using it. Understand what is the ratio of the judgment. Then cite it for your help or against you.
Exactly, very
There
much
may
said.
be many other observations in the judgment, but what is actually held by the judge at the end of the judgment, that is important. There may be many observations. Okay, so be careful of that. Now I think Sir,
First of all, thank you everyone for having us here. This is my first time here. Thank you for making me part of your third Intra Moot Court competition 2025. Someone is standing in front of the flex, so I cannot read it completely. So thank you everyone. I'm really impressed by all these speakers. One in particular, that is speaker 2 of the petitioner. But all of you are extremely good, and I'll suggest that all of you must give yourself a chance in litigation, because you people will do well. You're already in third year, fourth year, I saw the semesters. So please give yourself a chance, go to courts, see how it is like. And I want all of you to excel, because we don't find good people in coming to the profession, and you people are already on the way of making good lawyers. And also the researchers. One or two researchers were off, but it's fine. I understand the problem, where the problem lies, because I have 8 to 9 juniors of my own, and I know what they do, and I know that you people have done the same. But what you have done, I'll give you one suggestion, that don't get subjugated to AI. Harness AI. You should not surrender to AI. You should learn how to make the most out of AI. And for that, there is only one answer, that is to read journals, read journals, read journals. And I'll say this not only to the students, but also to the teachers who are present here. We cannot be archaic. We cannot rely on judgments which are 20, 25 years old, which Sir was emphasizing during the hearing also. We must be updated. And when you will, today we are in 2025, when you people will pass out in 27, 28, AI will take a different form altogether. So, if you ask a generic question to AI, AI will give you a generic answer. But if you know exactly what question to ask AI, AI will give you the right answer. So today when you ask something, the citations are sometimes wrong, the cause title is generally wrong. But what you need to do, you need to read journals to build up your legal language. If you don't have that language, you cannot speak to AI, and AI cannot answer you in a legal language. If you, for example, if you take a SCC online, and if you ask a question regarding retirement, you will not even get the best answers, because when Supreme Court has answered that question, Supreme Court has used the word superannuation. If you don't know that word, you cannot ask that question, and you can only know that word by reading journals. Use your libraries, use your seniors chamber, and read as much as you can. That is my only suggestion to all of you. And you have very good prospect in litigation. I'm sure others are also there who were in the other rounds. We could not hear them, but please give yourself a chance and just don't run after corporate jobs. Don't do that. If you have an opportunity, please come to litigation. Right? Thank you, everyone.
Yes, yes, very rightly said. One thing I will say, that I am really overwhelmed at seeing your confidence. Why I will say that it requires guts to move any matter before anyone, be a judge, be your co-colleague even who is acting as a judge. So yes, it requires guts. But see one thing, why you are hired as a counsel? You are hired as a counsel because you will not think emotionally. You will think by the eye of an advocate. That is oftentimes, even advocates, even we all are sometimes in our life entangled with litigations. But we never move our own case. Not because that we are not allowed to move. Anyone can move their own case before the court of law in person. But we always try to hire or entrust even our case to our co-colleagues or advocates. Why? Because doing our own matter is very difficult, because we might be emotionally connected to the matter. So if there is a series of questions coming to you, you should not panic. You should not panic. You should go calmly and understand the judge and answer properly. That is the thing. Now coming to the judgments, see regarding citations and all, whatever, how you search, I know very well. You go to Google and you search. Now what to search? That is most important, not the question. To identify the legal proposition, according to me, will make you an advocate. The day when you will be able to identify the legal proposition of the matter, because see, in most of the search engines, in most of the legal research tools, you cannot write the entire fact, right? You have to search with a specific proposition. So very important is to identify that specific proposition upon which you want to search and cite that respective judgment before the court. So that is most important. But what juniors mostly do is that they search in Google, and or they have a subscription in LiveLaw or other certain platforms, and mostly these platforms, just to get the TRP, they will flash you certain things and you will just read the headlines and you think, yes, this is the proposition of the judgment, this is the main ratio of the judgment, and you cite before the court. So that is why sirs have very correctly said, go through the entire judgment, only then you will understand what is the ratio and what is the obiter dicta. Otherwise oftentimes might be you have cited the obiter dicta, and a judgment once not set aside, be it of 1819, is also very well a precedent to the court if it is not set aside. But yes, obviously you should be updated and come up with newer judgments so that it is more acceptable, and you should also know the difference. I will not take your entire time, because otherwise I will be sounding very boring to you all. It's the end of the day and everyone is fatigued probably. So another thing is that you should know when a judgment is reported and when a judgment is not reported. Reported means it will act as a precedent. Anyways, I wish you all the best of luck. You are very bright students, and as Sarah has very rightly said, visit courts, come to litigation. Litigation needs young advocates and lawyers like you, because you are the pillar of our future. We will be no more, and the entire system will be held by young lawyers and advocates. So our country awards you all. So make your journey to be a successful advocate or a judge, maybe. I wish you all the best of luck.
Well, I think most of the learned members of this bench has already highlighted the various facets that this particular journey requires from you. From my side, I would request all of you to focus on the facts, because facts determines the law. So, for example, you push somebody, there is a specific law. If you ask somebody to hold the other person and then you start hitting that particular person, another law comes up. Now, suppose you hit with a rod, there's another law that comes into force. So, if you're not well acquainted with all the facts, you're bound to make mistakes in your submission. Number two, what I didn't find out is that there has not been a lot of integration between facts and laws. Okay? There has been a flow of the case, but the laws that has been discussed have not taken the company of the facts as it moved through the submissions. It's very important that you learn how to integrate the facts with the laws. Third, and I think the most important thing apart from the facts is where this particular case that you're dealing with stands. Stands means where it all started, what are the various roads that it has traversed, and where it is standing right now, and what are the other roads from this particular place, and why we are all standing on this particular point of the case. Number 4, you have to be very clear as to what you want. Very clear. And you need to keep on buttressing what you want with one point after the other, with one case studies after the other, with one aspects of the case after the other. And last but not the least, you don't come up with an argument to the court that the court do not have jurisdiction. Once you do that, if the court gets angry, you're gone. I hope you've got this point clear from all of us. So these are the 5 pointers: facts, integration of facts with laws, how this particular case stands in this particular court, how you are here representing whom, what you want from this particular court, and last but not the least, you never tell the court that the court do not have the jurisdiction to deal with this particular matter. So these are the 5 basic things which I think you should follow to carry on your endeavor towards your next moot court competition. Thank you once again. And it has been a privilege, to be here with this amazing bench, with members from the judiciary, from the members who are pleading before the Supreme Court, standing counsels of the Honorable High Court, and more importantly, the mentor, my mentor as well, Manik sir, who is right now your mentor. I think it's an amazing experience for me to be here at SNU again. I'd love to come back again sometime soon. Thank you once again.
We have now come to an end to the finals of the third Intra Moot Court organized by School of Law, Sister Nivedita University. And what a session it has been, right? So we are very grateful today to have with us once again our Honorable Vice Chancellor, Professor Dr. Shompu Bose, an esteemed panel of judges whom we have already interacted with at length, our esteemed faculty members, students and members of the Moot Court Society, participants who have outdone themselves today, I must say, and everyone gathered here today. First of all, a big thank you to all of you for being here with us. Can we please start with a big round of applause? So, without going into much more, I think we'll all go to that for which we all are waiting here today. So, we will now be declaring the results for all the categories. So, as you know that we will have the top 3 teams as well as the best researcher, the best memorial and the best speaker award. So, I would also like to bring to your notice that the best researcher has been based on the researcher's test, and the best memorial as well as the best speaker is based upon the marks given by each session during the preliminary sessions yesterday. Okay, so based on this, the results have come, and individually I'd request each of the judges and Vice Chancellor sir one by one to declare the result as well as to hand over the awards and the certificates to the candidates. Okay. I would like to request Professor Dr. Manik Chakraborty sir, Professor Emeritus of School of Law, Sister Nivedita University, to declare the best researcher and to hand over the award for the best researcher. Sir, if you could please come.
Hello. best researcher is Anushka Dhar. Thank you, Anushka. You have done an excellent. Thank you very much.
I think she was not expecting the award, so she's a bit unprepared.
Excuse me? Anushka? Sir, hotel.
I would now like to request retired Justice Indranil Odhikari sir to please come down to hand over the Best Memorial Award.
The winner is Team SNU 42. Tonu Ghoshal. Operator Ninao. Nahak. Olivia Nahak. And this is for the team.
So these are the winners of the Best Memorial. Thank you, sir. I would now like to request Advocate Shirshano Bandyopadhyay, Senior Standing Counsel, Government of West Bengal, to please come down to declare and hand over the Best Speaker Award.
So the best speaker is Shudipa Odhikari.
I would like to request Dr. Siddhartha Goswami, Advocate at Supreme Court of India and High Court at Calcutta, to come down to declare the second runner-up and to hand over the award.
The second runner-up is Samrat Moitro.
This is team number SNU 23.
Then there is Devashish Borai. And finally Shankadeep Poddar. So congratulations, this is the beginning of the new start. So we all learn every day. So congratulations again.
SNU 23. I would now like to request Professor Dr. Shambhu Prasad Chakraborty, Dean School of Law, University of Engineering and Management, to please declare and hand over the runner-up trophy.
The first runner-up is, I think this is the third Intra Moot Court Competition 2025. Who is Shumona there? And there you are. SNU?
27.
SNU? 27. Shudipa Adhikari. And Ritika.
Thank you, sir.
And here is your prize.
I would now like to request our Honorable Vice Chancellor, Sir, Professor Dr. Shankhu Bose, Sir, to please come up to declare the winner and to hand over the awards. If possible, I'd like to call the other judges as well.
So suspense. So winner is SNU 42. SNU 42. Huh? It's a big clap for the SNU 42. Olivia Nayak. Let's all come together. So, Shinjini Das. And so let's say, well, yeah. So, not from there. So, you are. So you all three hold together. Come. I will not be covered. Very big congratulations to them. Great beginning. Thank you. Wish you all good luck. Thank you. Thank you. Thank you. Thank you.
Sir, can I please request all of you to just... oh, this sir is leaving. Oh, sir, do you have to leave? sir, if you can stay for some time and hand over a few certificates, then okay. Oh, sir, then you can. Ha, chala, sir. Let's take a picture and then. Winners and runners up, please. Second runner-up, can we please have you as well? A bit fast, please.
Can we have the winners, first runner-up and second runner-up? Please come up on the stage. Best researcher, best memorial, and best speaker as well. Can we have the best researcher, please, on the stage? Can we have a huge round of applause for everyone?
Thank you so much, everyone. A big thanks to Vice Chancellor Sir for making time for this event. Thank you, sir. I would like to request the other judges to please remain here for a few more minutes to hand over the certificates to the participants. Pinky Chatterjee. Pinky Chatterjee. Sharthok Raut. Aditya Poddar. Mohammad Muzammik. Ronak Roy. Punit Jain.
Shreya De. Mohammad Muzammil. Certificate collect the certificate.
I would request one member of the MCS to please just take back the certificates if someone is not here.
Shreya Roy.
Madhushri Mitro.
I request Shreya Roy, Swastika Kormokar, Shomushri Dhar to please come up.
Madhushri Mitro. Punit Jain.
Next. Arushi Das. Best. Arushi Das, Rimpa De, Srijita Chakraborty, Priyanjana Chaudhary. Next, I would like to call upon Priyanjana. Are you there? Priyanjana Chaudhary. Rimpa De. Rimpa De is not here. Okay. Rimpa De, are you here? I request all the participants to please be ready for the collection of the certificates. It is an earnest request for all the participants to please be ready. Sorority Das, Devraj Roy, Shohani Roy, Mriganka Das, Srijita Chakraborty, request Mriganka Das to please be ready. Payal Singh, Mitali Maharaj, Aditi Ghosh, Devraj Roy, Shwani. I request Rimon Pine to please be ready. Pradipta Chaudhuri, Shuman Das, Onkita Aman.
Those who are done taking their certificates, kindly go back to your seats. Those who have already received your certificates, please go back and remain seated. Please do not create a
Rimon
chaos.
Pine, Pradipta Chaudhuri, Shuman Das, Onkita Anand. Mitali Maharaj. Where is Mitali Maharaj? Please collect your certificate. Aditi Ghosh, are you there? Dheeraj Sau, Ayush Upadhyay, Shomrat Moitro, Shankhodip Poddar. Dheeraj Sau, Ayush Upadhyay, Shomrat Moitro, Shankhodip Poddar. Ripon Pine, are you there? Rimon Pine. Devashish Borai, Priyam Malik, Biproshish Ghosh, Orgho Sardar. Sudipa Odhikari, please be ready. Sudipa Odhikari, Ritika Deb, Shumona De, please be ready. Shumona De, Ritika Deb, Sudipa Odhikari. সুদীপা এইগুলো যে নামগুলো বললাম একটু সিদ্ধার্থ গোস্বামী স্যারকে দাও I request Tomogno Das Bishwas, Otreyi Sen, Kaushik Bhattacharji, Mehak Akhtar to please come up. Ronak Ray. Ronak Ray. I would like to request Bidhi Daga, Sanjana Nondi, Yajat Dawal, Kritika Mohata, Munshi Anisha Tasnia, please come up on the stage. Sanjana Nandi, Yajat Dawal, certificates को दिया शो बाद में now I'd like to request the following contestants please be ready. Olivia Nahak, Shinjini Das, Tanu Ghoshal, please be ready for the certificates.
Rijoni Majumdar, Arshi Khan, Shayon Sen Chaudhuri, Anushka Dhar, Shomiron Behra, Ankita Mistry, Jahnavi Mishra, Jahnavi Mishra, Ashmita Singh, Priya Bachar, Ashmita Singh, Priya Bachar, Angela Shah, Ishika Bhattacharji, Balsin Sangma, Ishka Bhattacharya, Balsin Sangma, can I please request everyone to settle down? Can I please request everyone to settle down? Winners, runners up. We are all very excited for you, but then please settle down for a bit. Can everyone please settle down? I would request the respected judges, if they want, they can sit at the front row. Sir, আপনার বসুন একটু এই vote of thanks. Sir, আপনারা এই thanks টা হলে নিচে তারপরে Sir, এক minute. Please sit for the vote. Thanks.
Hello, hello. Sorry for keeping everybody awaited for such a long time. We have reached the very last segment of ours. I request all the MCS members to please come this side.
Please clear this space. Okay, so we have come to the very end of the sessions, and we are now almost done with the third Intra Moot Court, which has been a wonderful journey for everyone. I would now like to request Professor Bhaskar Mukherjee, co-convener of the third Intra Moot Court, to kindly deliver the vote of thanks to formally end the session. Can we please have a round of applause?
First of all, I would like to again say sorry for everyone to please to stay awaited for this such a long time. First of all, my heartfelt regards goes to all the judges for the finals. Again, I am buying that time, which is very costly, I know that. For all the judges for their immense contribution, not just as a judge for this finals, but also as a guide, not only by pointing out the flaws, but also addressing them, how they can work, how they can grow, how they can shine. In each and every way, they have pointed out the flaws. Again, they have addressed them in a very beautiful manner. Next, I would like to thank our VC sir, Professor Dr. Shonku Bose, Pro VC admin, Mr. Supratim Sen, Registrar sir, Mr. Shumanto Basu, CFO, Mr. Shubir Rokhit, our TIC admin, Pradeep Dr. Gupta, Director of Engineering and Services, Alok Bhattacharya, Manager of Maintenance and Operations, Gora Bhattacharya, to the Mass Comm department for capturing throughout the sessions. Thank you very much. To the IT department as well. And special thanks to the canteen as well. To all other administrative authorities of Sister Nivedita University. A sincere thanks to our Dean Ma'am, Professor Dr. Deboshri Mukherjee, and Professor Emeritus Dr. Manik Chakraborty sir, Head of the Department, School of Law, Dr. Bhanita Bose ma'am, to the convener of this event, Sumanjana Dotto Chottakondi, to the Moot Court Society and the participants, and to all the faculty members, School of Law, and to all the students for bearing with us. This event couldn't have been possible without the tireless efforts of all the Moot Court Society members, to all the faculties that they have segregated themselves, they have divided themselves, they have worked day and night to make this event a very successful one. The prelims and the semis as well as the finals have been possible gracefully only because of all the faculties have taken the in charge of all the departments, and under that all the Moot Court Society members have worked very beautifully. The leadership board, the executive board as well as the general committee members have worked really very hard. The participants have performed really very well. I would like to mention the judges that all the participants are performing for the very first time. Most of the first semester students are also here, 3rd, 5th, 7th. The Moot Court Society members are also in tireless journey of encouraging everybody to perform very well. And we somehow would like to work ourselves in this department and make SNU School of Law a huge success along with Moot Court Society. Thank you everyone. Good night.
I just have something to say. A big round of applause for Bhaskar, because he has worked tirelessly to make this event a grand success without budging for a moment, I should say that. And this, he really deserves a round of applause. Thank you so much.
I request all our respected judges, we can move to the lounge, VIP lounge.
Just one more minute, we'll be disturbing them. We want a photo with all the faculty members, I think.
I request all the respective judges to please come front.
After that, you can directly go down to the lounge.